Good morning, ladies and gentlemen. Good morning. It's a pleasure to have you all here. Thank you for coming this morning. Thanks especially to our distinguished speakers from all around the country who braved the winter weather back east to come out here to sunny California. We very much appreciate seeing you and so many of our friends, both friends of longstanding and relatively recent. Just a couple of administrative announcements. First of all, if you're looking for the Wi-Fi, it's the SCU Guest Network, and it should not require a password for you to do that. Those of you who are getting CLE credit, you know that there need to be written materials, so you can access them through that QR code. If you're looking for the restrooms, they're on the other side of the lobby, just to the left of the classrooms. You'll find the restrooms there. So the title of our conference today is How It Started, How It's Going. And how this conference started was a few months ago in the fall. We were talking about whether we wanted to host a conference this year and what the theme might possibly be. And of course, the first thing that came to mind for all of us copyright folks here was, hey, it's the 50th anniversary of the 1976 Copyright Act. And of course, great minds think alike, because within a few weeks, it turned out that half a dozen schools were doing a 50th anniversary conference on the 1976 Copyright Act. That seemed, so we figured we needed to do something a little different. And the breakthrough was when I came up with, hey, it's also the 80th anniversary of the Lanham Act, Federal Trademark Act. I'm like, okay, good. We got copyright, we got trademark. How about patent? It's the 74th anniversary. That doesn't fit, but it is the 15th anniversary of the America Invents Act, an important amendment to the patent laws. And it's the 10th anniversary of the Defend Trade Secrets Act. So suddenly we've got all of IP. We're able to broaden our horizons and invite so many subject matter experts from around the country. It's our pleasure to have you here. It's nice to see Dean Kaufman here. Thank you very much for attending. I think you'll hear briefly from him at lunchtime, but thank you for the support. And with that, I think we will go ahead and get started. Christine, if you'd like to join us.
Yes.
So each of you has a microphone here. It is turned off currently. So when it's your turn to speak, just click the on button. And if you're, and I know two of you are using slides, so I'll get those set up as we go along. So we have links to the biographies on the online site for the conference. So I'm not going to go into extensive biographical detail. We'll just go ahead and get started. Starting with Professor Christine Haight-Farley from the Washington College of Law at American University. And it's a great pleasure to have you here.
Thank you. Good morning. So I'm delighted to be here. I want to thank the hosts and organizers. Oh, it's not working?
If you pull the mic closer.
Oh. I want to thank the hosts and organizers for such a fun theme and meme. And I also am grateful for the challenge that they gave me to explain the history of U.S. trademark law in 10 minutes, which I hadn't ever asked myself to do before. I'm going to be very wedded to my notes so I can keep the time, and I've got lots of random little bits to tell you about. So the Federal Trademark Act, known as the Lanham Act, passed in 1946 after 25 long years from the first bill being debated and intermittently considered by Congress. That timeline, I think, was impactful. It allowed the major drafter, who was Edward S. Rogers, to have serial refinements in the bill and to learn from his experience as a litigator what was going on in the common law. Throughout the period, the common law developed dramatically. And the Act can be seen as transformative, especially in light of the stunted legislative developments before that. The 1905 and the 1920 Acts were essentially federal registration statutes. They did confer federal jurisdiction over common law infringement actions if it involved a federal registration. And Rogers aimed to throw out those acts and start anew, which he did. So the 46 Act went well beyond technical trademarks, which those previous acts had been focused on, and fundamentally altered the legislative picture for trademark law. And that act has not been replaced or overhauled since. However, the act can also be seen as measured and even conservative. It was not meant to supplant the common law or even codify the common law. Rogers maybe incorrectly assumed that Congress did not have the authority to create substantive rights beyond registration, or much beyond registration, or at least he didn't think Congress had the appetite to do so. So the act that emerged was mostly devoted to procedural issues related to registration and did not address some critical issues in trademark law, such as the scope of rights for defenses. The draft did invoke some substantive concepts like the likelihood of confusion, which I'll mention again, but where it did so, it just drew from common law. Nevertheless, there was a subtle reorientation of the law that was embodied in the act, which was significant. When Rogers joined the trademark law bar as a litigator, the law was concerned with the unfair diversion of trade from one merchant to another through deceptive passing off. Rogers witnessed and was actually a causal force in shifting the law from fraud prevention to the protection of property rights. He regularly explained the law in the most simple terms, but those simple terms were actually quite expansive. For instance, he said trademark law could be reduced to this single sentence: no one has the right to represent his goods as the goods of another. And he wrote in 1909 that judges had begun to appreciate business goodwill as the property to be protected. In 1914, he wrote a book, Goodwill, Trademarks, and Unfair Trading, that advanced this theory of goodwill as property, and it became a leading text. This idea of goodwill was extremely malleable. Under the common law, only trademarks, those marks which were arbitrary or fanciful and physically affixed to goods at the point of sale, were registrable. Everything else, including trade names, product packaging, advertising, descriptive terms with secondary meaning, had to be protected under unfair competition. Rogers' practice somewhat specialized in these unfair competition claims, and he advanced the law dramatically. Having business goodwill be the property rather than the trademark was a genius move because it was infinitely more flexible than protecting only what was protectable as a trademark. Rogers believed that there should be no distinction between a case involving a technical trademark or trademark infringement and unfair competition, and his bills, as they moved forward, progressively eroded that distinction. Ultimately, the Act did allow for the registration of descriptive marks with secondary meaning. And the Act included consumers' perception rather than the trademark as the measure of the rights, and that was an equally genius move. It provided a principled limiting mechanism that responded to critics who feared trademark law could create perpetual monopolies. Rogers sought to maintain the robust common law that he had extended. He knew it well himself, having litigated many of the critical cases. For instance, in 1917, he won the Aunt Jemima case, which convinced courts that trademark rights should extend beyond direct competition to related goods where a consumer would be confused about the source of origin. Previously, trademark rights had been limited to goods of the same descriptive properties. The Aunt Jemima case challenged this framework, focusing on consumer perception rather than direct competition. 10 years later, Judge Learned Hand, who had been in the majority of the Aunt Jemima case, took this one step farther and held that Yale for locks, that trademark could be enforced against the seller of light bulbs. These goods were not even related. And these developments did provoke accusations of creating monopoly rights. However, these critiques caused Rogers to avoid producer-centric rationales and to argue that trademarks ensure information clarity for consumers. Courts began to articulate this theory and say that the primary function of trademarks was to identify the source of origin of goods. Rogers argued that by preventing consumer confusion, trademarks enabled informed consumer choice and thereby furthered competition. The 1946 Act defined infringement as any use of the mark that caused confusion as to source of origin of the goods. Once these concepts became enshrined in the statutes, courts began to embrace them more openly. But the Act did not go as far as some wanted it to. Rogers didn't equate goodwill with brand value or with a freestanding right in meaning. Instead, for him, goodwill existed in the relationship between the seller and its customers. Accordingly, producers were protected against damage to goodwill through confusion, but not uses that would weaken their mark. By the time of Rogers' more mature bills, the common law had developed so fulsomely and uniformly that there was no perceived need to create any new federal rights in the Act. Rogers drafted Section 43A as a very narrow provision on false advertising, drawing language from the Pure Food and Drug Act. Neither he or Congress intended 43A to serve as a comprehensive federal unfair competition provision. And after passage of the Act, courts continued to decide unfair competition cases by purportedly applying state common law. The law here grew more robust until the 1964 Supreme Court in Sears-Comco, which held that many state unfair competition laws were preempted by federal patent law. And this created a crisis that ultimately affected how the Act was interpreted. If Erie meant that federal courts couldn't create federal common law, and Sears-Comco meant that state law was preempted, where was the unfair competition claim to be found? Trademark owners found their answer in Section 43A, and courts began reading the prohibition expansively. Rogers' innovations in protecting goodwill across non-competing goods, using consumer perception as the measure of rights, contain the seeds of broader protections that we will talk about later. Thank you.
Thank you very much, Christine. Really interesting to hear that history encapsulated in only 10 minutes. You did beautifully, so I very much appreciate that. Our second guest is Professor Sharon Sandeen from Mitchell Hamline College of Law in Minneapolis. And of course, when we planned our conference, we didn't know today would be a day of action. We're not supposed to be working. But fortunately, if you know IP professors, you know that we don't think a conference like this is work. This is fun. So, and she's going to be talking to us about trade secret law.
Well, thank you. I'm very excited to be here, not only because it's the 50th anniversary of the 1976 Copyright Act, but because it's the 50th anniversary of my first trip to Santa Clara County, unless you count all the times I skipped school to go to Santa Cruz and had to drive through. And the occasion of my first trip to Santa Clara was, believe it or not, my high school graduation party at Great America, which had just opened, 50 years ago. So you can tell from what I just told you, I'm a proud East Bay girl, and happy to be back in the Bay Area to talk about something which, of course, 50 years I didn't have any idea I would be sitting here. I was going to go be a forest ranger or something, 50 years ago. That's what I was thinking about. What you will hear from my presentation relates a lot to what Christine just talked about, but I'm going to start with Erie. Now technically, trade secret law started in the United States in 1837 with the first recorded case. But I have decided recently, and for all the lawyers in the audience, I've decided to stop telling that story. And the reason why is because too many people are clinging to the common law of trade secrecy when we shouldn't. The law changed with the adoption of the UTSA and later the adoption of the DTSA. And it's very important to understand how it changed and why it changed. So I'm going to start with every first-year law student's favorite case, Erie Railroad versus Tompkins. And you struggle to figure out what the heck did that mean. And the Supreme Court said, well, we can't make federal common law. But there was another aspect of it, which is, well, when you can't make federal common law, where do you go to look for law, right? And where you go to look for law, according to the hierarchy that the Supreme Court set forth in that case, is you look at state common law first, because there is no federal common law. So that happened. Now, just coincidentally, in 1939, the American Law Institute published the first restatement of torts, and it was in the drafting stage, obviously, before the Erie decision came out. And in that edition, there were 3 sections having to do with trade secret, which purported to set forth trade secret law, better reason trade secret law as of 1938, or 39, excuse me. The problem is there wasn't much trade secret law in the United States in 1939. So what is shocking to me, I went to the ALI headquarters in Philadelphia and looked at the documents, and they were writing restatements based on like 20 cases, And being a native Californian, I think it's also important to understand that the history, and I don't mean this pejoratively, but the history of the restatement was East Coast elitism. And they didn't like the upstart Western states that wanted to adopt the field code and develop their own common law, not cling to the English common law and so forth and so on. So anyway, but the restatement first was the operative law, and cited a lot from 1939 until the UTSA was adopted in 1979. But it is now not the law. Don't cite it anymore, except if you live in New York. Okay, so what led to the adoption of the drafting of the UTSA? As Christine alluded to, after Erie, there was this incredible effort by the IP Bar of the United States to adopt a federal unfair competition law, which would include a trade secret. So they were actually, at one point, talking a lot about amending Section 43A of the Lanham Act to include more provisions because of the concern about the absence of common law of unfair competition. And so there was this bill introduced every year. They ended up calling it the perennial Lindsay bill. Lindsay named after Congressman Lindsay from New York. he'd introduce this bill every year to expand the Lanham Act and create a federal anti-competition law that would include trade secret provisions, and it always failed. And so finally they decided, well, we just have to do a uniform law. And they went ahead and did the uniform law, and they were drafting it. And what ended up happening with respect to that effort was what I label, and Christine alluded to this, I labeled it the Erie Sears-Comco squeeze. And the squeeze was you can't have the development of federal common law, but the Sears-Comco cases also restricted the ability of state common law and state statutes to develop to the extent that they would interfere with patent law. And so that was the problem. And the drafters of the UTSA were aware of this problem and were trying to work it out by coming up with a uniform trade secret law. About that time also, a series of cases happened that had to do specifically with trade secret law. A case in New York that's not talked about much called the Pantone case basically said that state trade secret law was preempted based on the Sears-Comco reasoning. So it wasn't until Kiwani in 1974 was decided that they could actually go forward with this project that started in 1970 and finish the drafting of the Uniform Trade Secret Act, which finally got, as I mentioned, adopted in August. But it's important to understand that history because as they were drafting this, they knew they had to limit the scope of trade secret law. They knew that if they drafted trade secret law too broadly, it would be preempted. And so, and I say this now because a lot of people say, well, maybe we should expand trade secret rights, at least at the state level. You can't, unless you want to face a preemption problem. But there were other reasons why they limited the scope of trade secret law, which is very important to understand. The main reason is they thought that the definition of a trade secret was too amorphous and unpredictable, and they wanted some more certainty. And so they came up with a three-pronged test that must be met. They thought that some of the remedies were too broad, like perpetual injunctions, and they wanted to get rid of those. And so, if you leave with one thought today, leave with the thought that the UTSA was designed to limit the scope of trade secret protection and provide more balance between, for competitive reasons. Thank you.
Next up, we have Saurabh Vishnugopath from Cardozo School of Law, Yeshiva University. And now this won't challenge my technical skills because I've got to get his slides up on the screens, but I think I can manage it. And we've got a clicker for you, so you can advance your slides.
Thanks so much. Well, good morning, everyone. It's really a pleasure to be here. My remarks will focus on the way in which patent law, which is, sort of how it started. Well, it depends on what you mean by it, but I'll take you back to 1793 for a brief moment, and then I'll get you back to the mid-70s where we all yearn to be. But rather than give you the administrative law history of the USPTO, which is an institution that I study and care about quite a lot, I will give you two histories of the USPTO in a very short time. And then I'll do a bit to explain what I think was going on in the mid-70s that really set the stage for the world we live in today as a matter not only of patent law, but of patent institutional practice. Okay, so to begin with the conclusion, I think for most of U.S. history, adjudicatory power and political accountability, these two threads of administrative law in the USPTO ran together. But then starting in 1975 and accelerating in 1999, these two trends split. And the consequences of that split are what we sort of live with today. So as far as the adjudicatory power story is concerned, that power steadily moved downward from principal officers to inferior officers to mere employees at one point. And the adjudicative apparatus was really sort of subordinated and actively subordinated, while political accountability and the agency leadership's position in the executive branch, as it pertains to the cabinet and advising the president on intellectual property law and policy, moved upward, and it thinned out, so there was only one person. Now, this sounds like a unitary executive theory story. It's not. And if that's something you want to talk about, I'm happy to take questions about that later on. But the basic sort of story here is that we are subordinating a group of relatively co-equal adjudicators at the same time that we are pushing the agency's political leadership upward and sort of aggrandizing them and giving them greater control and supervision over everything that happens in the rest of the agency. Now, the Supreme Court's 2021 decision in United States versus Arthrex is clearly a response and a reaction to this trend that began in the 1970s. And the court is, I think, trying to put these two trends back into alignment. I don't think they really succeeded fully, but that's just in the nature of what you can do as a court in a particular case, right? So let's talk about the history that got us to Memphis, as it were. So 1790 to 1793, the founding era, we have substantive examination of patents. It's done by 5 people who have day jobs in George Washington's cabinet, the Secretary of State, Secretary of War, AG, and others. They're all presidentially appointed, Senate-confirmed principal officers, and they are the patent board. And the cabinet officers themselves are the political leadership of the agency. So the adjudicative apparatus and the political leadership are one and the same. Okay? Pretty soon, Thomas Jefferson decides he can't do this all on his own in his bed by candlelight, so we go to a period of registration. 1793 to 1836, there are occasionally arbitrators in interference cases. They're chosen sometimes by private parties, partly by the Secretary of State, but they're not executive officers in any conceptual sense, and their decisions are not conclusive. The political leadership remains the Secretary of State. Now, in the White House, the executive office of the president, there is a superintendent of patents. That is the forerunner for the person who will later become the first commissioner of patents. This person is appointed by the secretary, not Senate confirmed, so the superintendent is at best an inferior officer. The 1836 Patent Act. This is really a watershed because we now have, for the first time, an office, a bureaucratized agency whose job it is to administer the patent system. We restore substantive examination, patent searching, library, and so forth. The boards of disinterested persons, they're appointed ad hoc. They're still not styled as executive officers. And meanwhile, the political leadership remains the commissioner, but the commissioner is not the inferior officer setup of the superintendent. Rather, it's a Senate-confirmed principal officer who is then subordinate to the Secretary of State, who's also a principal officer. So this carries on for a few years, and then things get more robust, right? The maturation of substantive examination comes when the Secretary of State is sort of taken out of the picture as a practical matter. The Commissioner for Patents remains a principal officer, presidentially appointed, Senate confirmed. We move from the State Department to the Interior Department in 1849. The other patent adjudicators are now Article III judges. We still don't have executive officers as such, but district judges, under the supervision of the chief judge of the Court of D.C., is hearing patent appeals, and these folks are basically moonlighting. They're compensated extra over and above their judicial salary in recognition of the fact that what they're doing is fundamentally not judicial in nature. It's quasi-judicial. It's a step toward formalized adjudication inside the patent office, but we're not there yet. This continues on until We add trademark operations to the mix. The office is now really an IP office for the first time, and we see examiners in chief. This is, I think, the adjudicative moment that really sets the stage for the next century, because examiners in chief are the forerunners of our modern administrative patent judges. These folks are created as a standing office. They too are presidentially appointed, Senate confirmed. They sit on a board, and the board that comprises all the presidentially appointed examiners in chief take appeals. You could still have recourse to the commissioner in person, but for the most part, these examiners in chief are taking the adjudicatory reins. The Commissioner for Patents remains a principal officer. We go from the Secretary of Interior now to the Secretary of Commerce in 1925, where the office remains to this day. And the stage is set for the run-up to the 1952 Act. In the 1952 Act, much remains the same. Examiners in chief are still principal officers. The Board of Appeals consists of these principal officers, including examiners and assistant examiners in chief. And in addition to the Commissioner for Patents, who's a principal officer, we have multiple assistant commissioners who are also appointed by the President and confirmed by the Senate. So you can see the principal officer corps inside the agency growing pretty robustly. After 1952 into the modern era until 1975, this is the high water mark of presidentially appointed, directly politically accountable leadership, both at the head of the agency and in the adjudicative apparatus of the agency. Now, why does this matter? Because, well, in 1975, the wheels start to come off the wagon. The examiners in chief are all converted to civil service officials. They're no longer appointed by the president or confirmed by the Senate. They're appointed by the Secretary of Commerce. They have tenure protections, but the boards are increasingly dominated by civil service examiners in chief. Some presidentially appointed folks who are sort of previously appointed that way still sit, but they're sort of starting to thin out in the ranks. The political leadership is reduced from 19 presidentially appointed principal officers to 4. It's just the commissioner and his deputies. And the commissioner, starting in 1982, starts to get a political ascendancy. They're no longer only the commissioner for patents and trademarks, they're also an assistant secretary of commerce. And Jim Rogan was the first to occupy that dual role, and this continues through the years of the Reagan administration. In 1999, this is where I think the bottom falls out. Examiners in chief are renamed APJs. Now they're not even appointed by the secretary, but by the director of the agency. This is a constitutionally defective appointment. At the very least, they are inferior officers. They have to be appointed by a head of department. Congress realizes this fairly quickly and fixes it, but the PTAB panels have been comprised of these deficiently appointed folks for some time, and the director of the USPTO remains now the only presidentially appointed person in the entire agency, and they go from being an assistant secretary of commerce to an undersecretary of commerce. So the adjudicators are being subordinated more and more and more, while the political leadership is being thinned out and given greater and greater visibility in the executive branch. What happens in the run-up to the AIA? APJs are now once again appointed by the Secretary of Commerce. That's great. PTAB panels have these folks on them, and the director position, the undersecretary position, remains as it was. For the next 10 years, the decade following the America Invents Act, APJs remain inferior officers, but we now have a massive new administrative adjudication apparatus in inter partes review, post-grant review, covered business method review, and so forth, in addition to ex parte appeals and ex parte reexaminations. So there's a great deal more work to do, and their decisions in the PTAB, the adjudicative decisions, become final for purposes of just the last word of the executive branch. That finality of decision-making is putting increased pressure on this visible, highly powerful person in the director's chair, but that person's ability to supervise and control those supposedly inferior officers is compromised. And so the agency head is restored to supervision, but it overextended after Arthrex fixes the immediate problem. And so how did it start? Here in 1975. This was the inflection point. And although I'm loath to share this with the internet, I don't mind telling you, here's how it started, and here's how it's going. Thank you.
So if you're following us on social media, we asked all of the speakers, if they wanted to submit pictures from 50 years ago. It started with us internally, of course, and then once word got out, everyone's like, "Yeah, we're going to do that." So do check us out on social media, and you'll find a series of these pictures. At least for those of us who were active 50 years ago. And then our final panelist is Professor Fred Yen from Boston College. And we're very pleased to have him here today. And let me pull up your slides.
So thank you to everyone at Santa Clara Law School for having the prescience to schedule this so I'd have an excuse to leave 0-degree temperatures. Not only that, but to arrive at the San Jose airport to be greeted by Super Bowl signs in this most improbable year where all of us are thinking, what, the Patriots are still playing football? Football games in February? So this is really a wondrous thing. I think there's a lot of overlap in some ways between my remarks and those of Christine and Sharon that I'm curious about the intersection between common law and codification. And what I propose to talk about here today is, I'm going to call it a taxonomy. Did it move? Yes, okay. Because I think that when most people hear that the 1976 Act at various times codifies the common law, that whatever the judges have been up to for the previous 50 years or whatever will continue the same. The law does not change, the judicial development of the law doesn't change, and that's, after all, what codification of the common law means. And I want to suggest that that's actually not what happens. Sometimes that happens, but not always, and that's the purpose of the taxonomy that I'm offering. And so I want to talk about 3 instances in which I will suggest that you can see the codification of common law happening in the 76 Act. So, for example, Section 102B, codifying the idea-expression dichotomy. Copyright does not protect ideas. Section 107, the codification of the judge-made fair use doctrine. And then what I'm going to call here an implicit adoption, the Digital Millennium Copyright Act Safe Harbors, Section 512, which at least accept the existence of third-party copyright liability into the law, even though there's no provision in the 1976 Act explicitly so establishing them. Now, the reason I've chosen these 3 examples is because I think they illustrate 3, and I'm sure we could come up with more if I only had more imagination, ways in which the 1976 Act winds up interacting with the common law. One would be the common law continues undisturbed, that what you see today in adjudication in the 1976 Act looks a lot like something you could have imagined if the 76 Act had never come into existence. The second I'm going to suggest is that the codification impacts the common law, but I'm not sure if it has impacted it consequentially. In other words, I think you can see judges deciding cases differently than they would have in the absence of the 1976 Act. Whether the cases are coming out differently, I don't know. And then, although I don't have an example of a case that does this, but a case where, in this case, a court could use the 76 Act codification to reach a result which I don't think is contemplated under the common law, to actually change the development of the common law because of codification in a more meaningful or substantive way. So, for my first example, just for those of you who aren't familiar, right, the common law origin of the idea-expression dichotomy is commonly traced to the Supreme Court case of Baker versus Selden, codified in Section 102B of the Copyright Act. And the House report says quite carefully, Section 102B in no way enlarges or contracts the scope of copyright protection under the common law. Its purpose is to restate the basic dichotomy between expression idea remains unchanged. So to me, that's a statement that we didn't want to change anything. We just wanted to say we're okay with it. And I'm going to suggest that in this particular case, in part because of the language of Section 102B, which pretty much says ideas are not protected by copyright, that what you see going forward looks a lot like what you see going in the past. So you could compare the kind of reasoning you might see in Baker versus Selden or Nichols versus Universal. That's where the famous levels of abstraction test is created by Judge Hand. And maybe a case like Computer Associates versus Altai, where you have the court citing the copyright statute, but beyond acknowledging that the idea-expression dichotomy has been codified in the Copyright Act, pretty much goes about business the way they might have gone about it in the absence of the Copyright Act. Now, I think things are a little bit different when we get to the codification of the fair use doctrine. Again, commonly traced to a judge-made doctrine here announced perhaps in Folsom versus Marsh. Now, we all know that Section 107 did not simply say the fair use of copyrighted materials is not infringement. Rather, Congress codified the well-known four-factor test, looking at the purpose of the borrowing, the nature of the copyrighted work, the amount borrowed, and the effect on the market of the copyrighted work. And the copyright said that analysis of fair use shall include these four factors. Now, again, the House report says we're not meaning to change anything. Section 107 is intended to restate the present judicial doctrine of fair use, not to change, narrow, or enlarge it in any way. So again, if you just went that far, you would think that the codification is meant to say, we accept what judges have been doing for decades, let's not change a doggone thing. But of course, I think that the existence of the statute has changed how judges deal with fair use, because the statute says the factors shall include these four factors. And if you look at pre-1976 Act cases, there's any number of decisions which did not, in fact, consider all four factors, or did not even necessarily proceed with those four factors. So to give, for some contrast here, we could look at a case like Williams and Wilkins versus the United States, a 1973 fair use case, which held that the provision of photocopies to requesting scientists by libraries at the National Institute of Health and the National Library of Medicine was fair use. Now, the court explained its decision with these considerations I have up in front of us. The defendants are not-for-profit institutions. The requesters are scientists using the copies in their work. They don't distribute the copies that are made any further. Libraries have limitations. In other words, the lending libraries have limitations. They would typically give the scientist only one copy and generally less than 50 pages. Library photocopying is a long-standing practice. Stopping practice would harm medical research. Plaintiff had failed to demonstrate substantial financial harm. In doing this, the court specifically rejected what it called economic theorems, that any substitution by the alleged fair use must cause harm. And they noted that many foreign countries have specific provisions that would make this kind of behavior non-infringing. So I would suggest that doesn't really, although the court acknowledges that Congress is considering a statute with these factors in it, they went off and did something that looks a lot different for me. Now let's compare that with the American Geophysical versus Texaco case, in which the photocopying of articles by or at the request of Texaco researchers was held not to be fair use. So, Texaco had a librarian who circulated copies of, various scientific journals related to oil refinery, and scientists would get the copy of the journal and say, I want a copy of this article, and they would keep it. So now, in this case, the codification of the 1976 Act is acknowledged. The court expresses doubt that the codification applies well to these cases. In other words, the court says that this is really about people who borrow small amounts or parts of works and make completely different works, not people who are busy photocopying works for science. But since we have to do it, we've got four factors here, and so let's go through them. And they said factor one, on balance, favors the plaintiff because primarily the dominant purpose is a systematic institution of multiplying the available number of copies of pertinent copyrighted articles in a commercial setting, as opposed to for-profit corporation. Factors 2 and 3, scientific factual works favors the defendant, the entire work copied favors the plaintiff. And then in factor 4, copyright clearance set or revenue is lost, therefore this favors the plaintiff. Now note, what I'm suggesting here is that these cases are not necessarily being decided differently, but they are being reasoned differently than before the act. Okay, now quickly on to the last possibility. I want to give an example of what I think is the common law disturbed. And so this would be contributory liability and safe harbors under Section 512. So common law comes from, for contributory liability, comes from the Gershwin case. Congress says in the DMCA, the failure of the service provider's contract to qualify for limitation of liability in the section shall not bear adversely upon the consideration of a defense by the service provider. In other words, whatever the underlying common law is, it's not supposed to change. In other words, we understand the safe harbors as a solution to the ambiguity of existing common law. If the common law should develop in a direction that makes the safe harbor superfluous, so be it. One more slide. Thank you for the warning.
Go ahead and finish.
Okay, so now, in Sony versus Cox, right, okay, in the oral argument, there was considerable discussion about the significance of the safe harbor for our understanding of the underlying law of contributory liability. So, for example, on page 38 of the official transcript of the argument, Justice Jackson is asking Cox's lawyer, if Congress wanted safe harbors to, that makes the observation that Congress wanted to safe harbors to incentivize service provider cooperation to get rid of copyright infringement. And if Cox was correct in arguing that it could be liable only if it intended for its subscribers to commit copyright infringement, then the service provider would have no reason to comply with the various prerequisites put down as incentives for getting the safe harbor. Paul Clement, Sony's counsel, repeated the argument that Justice Jackson suggested to Rosencrantz in his opening of his oral argument. And I would note that if the Supreme Court adopted this as a reason to not make intent part of contributory liability, I would suggest that exactly the opposite of what codification of the common law means would have happened, namely that we would have used codification that was not supposed to disturb our understanding of the underlying common law as the reason to construct the common law in a certain way, which I suspect I would consider a mistake. And so some possible implications, maybe it would be better if we wanted to have full acceptance of the common law, keep the codifying language simple, like 102B. Some codifications may not, in fact, be codifications. So we get sort of like the kind of debate that we get about restatements. So the restatement of torts really a restatement of the torts, or is it a change of the tort law? And I think finally, courts have to be very careful about using the statute and its recognition of common law correctly. So thank you, and sorry for the extra time.
No problem, because we've got plenty of time for discussion among our various panelists. This particular panel is looking back in history to see sort of how things came to be. And, I'm very fond of studying history, but it strikes me that there are two different things that happens. One is sometimes you can't understand how the law is today without looking at how it came to be, right? It only makes sense because of a path dependency that it evolved in a particular way. And then sometimes it's like, well, looking at that history is fun, but what has it got to do with the law today, right? The law has changed so much that the history is sort of basically irrelevant other than, well, that's interesting, but that's not how it ended up. So I would ask you if you can think of examples in the areas that we've talked about here. Is there an example of path dependence where, wow, this is something where you really need to understand the history in order to understand how things ended up this way? And are there examples where it's like, well, things have changed so much that we're looking at this history, but it's just not really what they intended to happen. And I think we've heard some examples of that in your introductions. I would ask each of you if you can respond to one or both of those examples in the areas that you're talking about.
Am I on? This allows me to talk about something that I couldn't squeeze into 10 minutes that I love to talk about. Yes, I think without looking at history, we can't understand Section 43A, and we can't understand. Broader thing we can't understand. We can't understand where is unfair competition in U.S. law. I think in other jurisdictions they have a clearer other set of rules that we just don't seem to have developed. And I think that is because of the strange history of Section 43A, and maybe, well, no, let me just leave it at that. That it was not meant to be in 43A is all I said in my 10 minutes. What it was meant to be is in Section 44. And again, it was the very conservative approach that Rogers took to drafting the federal act. He referenced, and it was something that I thought would be interesting to raise with the others, we've been talking about common law and codified law or statutory law. We haven't talked about international law, which is also kind of out there. Is it in the statute? Where is it? How do we deal with it? So Rogers had a whole section dealing with international law and just planted our international obligations in one section, and did so with explicit shout-outs to two treaties, which have been removed. But it was this kind of very subtle insinuation about what the rights would be. So something that I think we don't understand today is that there was a healthier understanding of self-executing treaties at the time, during the duration of the drafting of this act. And now we think that, I think maybe we lazily think that treaties need to be implemented by Congress. So what does it matter if there's a section that mentions other treaties and obligations? Unless Congress has specifically enumerated those rights in this act, they don't exist for all intents and purposes. But that was not Rogers' understanding. And so the unfair competition that was really detailed and elaborated and went beyond trademark law was in these treaties, especially the Inter-American Convention, and that was mentioned and incorporated by reference. But that there are a couple of cases that followed that path, and courts lost that path, and it was at the same time that 43A began to open up. So that was just a strange detour the law took.
Hello.
Well, I want to make
Escucha, el
a
miércoles.
point, but I want to follow up on that because this is really important, I think. During this period that I mentioned, and I'll just focus on the drafting of the UTSA. In the lead up to the drafting of the UTSA, when they had these committees that were worried about the effect of Erie, they were trying to, the business community / IP community was advocating for more laws to control and prevent unfair competition. Okay, get your head around that. That's what they were advocating for. The Unfair Deceptive Trade Practices Act is an example. And somehow from that period to now, we got rid of all that. Okay, most of that. And what we have left is trademark law and trade secret law. That's it. And for those of you sitting in there, well, what about all these claims of like misappropriation of confidential information? They're gone. If the UTSA is applied, Section 7 of the UTSA is applied correctly, they're gone. They don't exist anymore. Well, what about International News Service? It's gone. It went away with Erie. So all these cases that when I was a practicing lawyer in California, I used to cite, they're not good law anymore. They just aren't. And we have to recognize that. I mean, we can have a debate whether we want those laws to come back and in what form, but they don't exist anymore. And this is really important for me as I consider myself more of an information law scholar than not just a trade secret scholar. And the reason why is I care about, and I think a lot of people in the room care about the flow of information, particularly in this day of AI, and I don't want it to be locked down because somebody's claiming they have an unfair competition claim. You don't. If it's not a trade secret, you don't have a claim unless it's a breach of contract claim. Now, related to that, the six-factor test of the restatement first is gone. It's not the law. The UTSA replaced it intentionally. It might still exist in New York, but it doesn't exist anyplace else. And cases and lawyers, it's still cited for making a mistake. So there is a point where if you don't understand the history of how the law was developed, and keep in mind, this is not a case of a judicial decision being overturned where we can jeopardize it. It's a situation where unless you know the history, you don't know when the law changed. And we know that with the 1976 Copyright Act because it was a federal law, but we don't know that as well with the trade secret law.
So, I think the answer to both questions in the context of patent law, right? I mean, the law of patents, the substantive law of patents, didn't change over this time period. It doesn't map onto the periodization that I laid out. But the problem that Congress thought they were solving, I think path dependence depends a lot on path selection. Congress was making a very conscious choice in 1975, and the motivation behind that, I think, set us on the path we are on today. It clearly had unintended consequences because what they were trying to do in a sort of immediate post-Watergate environment is express their widespread skepticism of executive power and sort of congressional assertiveness rather than allowing presidential aggrandizement to continue. So what problem does Congress think it's solving? They're solving a problem, not of bureaucratic entrenchment. That's the solution. That's the feature, not the bug. They are expressly distrustful of presidential appointees, politicized decision-making. And so what they want is quite consciously to thin out the herd of presidential appointees who are going to do the president's bidding, serve at the president's pleasure, and so on. So they're not trying to preserve political accountability. That's not the problem they're trying to solve. They're trying to say, we need to insulate technical decision-making, which is safe, relatively non-political in the adjudicative setting of the patent office. So we need fewer presidential appointees, more civil service officials, stronger tenure protections. And those are the very things, of course, that the Supreme Court, starting in 2010, really takes an aggressive aim at with Free Enterprise Fund and all the cases that follow. So if you have a view that administrative adjudication in the USPTO is fundamentally quasi-judicial and ought to be treated as though administrative adjudicators are just Article 3 judges light, then you're completely missing the mark on what the administrative law problem of the last 25 years has been, as opposed to the 25 years preceding. Because the problems of Watergate in the immediate post-Watergate environment are what Congress was dealing with at the time. And now the immense expansion of the importance of patents, the robustness with which administrative adjudication takes place, all of that puts administrative adjudicators in a completely untenable position. It's not the safe, out-of-the-way, unimportant thing it was in 1975, but if that's what you think when you are sort of constructing the appointment and responsibility of these civil service, these civil servants, then you're necessarily going to wind up in the tension that Arthrex at least partly tried to resolve, but much of which remains in force today.
Okay, so for things where path dependence appears to matter, I think that the last example I used is actually a good example where you have to understand, in order to make any sense of the DMCA and its safe harbors, the notice takedown provisions, any of that stuff, you have to understand how they got there. You can't just read it in a statute and go, oh yeah, I know what that's about. I think it's impossible. Just in the area of copyright, I would also say if you're trying to understand duration and termination provisions, it helps a ton to understand how we got there. In fact, I'm not sure I don't know how I could explain this to anybody other than that way. Now move to fair use for a moment, since that was a part of my presentation also. There are definitely times I think that path dependence might help us understand fair use a little bit better. So, for example, if one understood the path dependence of fair use, one might have a different attitude than maybe present courts do to duplicative uses, photocopying and things like that. They might more often be considered fair use than they otherwise would be. And to the extent that we have fair uses of, entirely duplicative uses, I think courts twist themselves into knots trying to stuff everything into the transformative box. I think if we understood that the prior law of fair use did not require transformativeness, then maybe the doctrine of transformativeness wouldn't be so hard to understand. Now, for something where I think path dependence seems very far away, when I start thinking about fair use in the training of AI, path dependence seems very far away now. I think that so much is debated, is going to be driven by modern policy, however you choose to see this, that to me it feels farther away than some of the other examples that I suggested.
So next I'd like to ask the panelists whether they have any questions for each other. And I'm going to start with one for Fred. When you talked about the idea expression distinction being codified in the 1976 Act, and the suggestion was, that was sort of a clean codification, didn't really affect how things were decided later. But I would suggest that perhaps, in addition to that, what happened there was that the ground shifted underneath the underlying assumptions, which is in the 1970s, we got an underlying assumption of statutory interpretation that involves a lot of legislative history and context and policy. And we've changed to a world where plain meaning is something that judges profess to have adherence to. If we didn't have that codification, I really wonder what would have happened to idea expression. I don't know if you have any thoughts on that or not.
I'm not sure I have thoughts about that directly, because the statute still forces a judge to identify what is an idea, and doggone it, I'm not sure exactly how that's supposed to be done, but they do it anyway. The area where what you suggested really made my ears perk up, which was plain statutory meaning and largely judge-made doctrine, would be Star Athletica, where Justice Thomas says, "Oh, come on, just read the copyright statute, man. I mean, it's obvious what the answer in this case is. Read the copyright statute." Heavens to Betsy, for the life of me, I haven't managed to figure that out yet. But there's a good example of where I think the court's inability to acknowledge the full richness and complexity of the useful article doctrine in favor of the sort of, the text tells you the answer, really leads to, an impenetrable and frankly unhelpful decision.
So, do any of you have questions for any of the others, please?
Yeah. So, Christine, I want to ask you about Sears-Congo, because what you're saying sort of makes historical sense, and of course it is indeed what happened. What I'm not sure about is why it was necessary to go to 43A as a theoretical matter. So if the problem is that federal patent law is preempting state unfair competition law in Sears-Congo, as between the two of them, you can still under Erie have state unfair competition law to the extent that it's not preempted. So at least conceptually, you could imagine, okay, whatever patent law provides, you can do unfair competition-wise. And to the extent federal patent law doesn't do it, state unfair competition law is capable of filling the entire gap. If that's not true, and therefore, the sum is actually less, or the whole is less than the sum of its parts, then you would need to go to 43A. But it's not clear to me why the total is less than the sum of its parts, unless state legislatures are overly cautious about legislating in the face of preemption, or federal patent law isn't being used to its full sort of available scope, which seems implausible to me, just based on how patent litigators are. But what is the sort of rest of the story that creates the gap? Because conceptually, it's not clear to me that a gap is necessary, but it clearly exists.
It's a great question. I think part of it is I don't know the answer, because when I read what happened after Sears-Compco within the trademark world, it seems like there was mass hysteria. Like, honestly, there were so many law review articles written about, like, oh my God, the sky has just fallen. What are we to do? There was not any state law. It was all, there was always federal common law. That's really all that was there. I think it's a path dependency issue again, that it just made people focus on Section 43A as a way, especially in the light of hysteria. So I think, was the hysteria manufactured to get some legislative action? I don't know. There certainly were calls for amendments. But I think it was just a confluence of people were saying this was a terrible development, where would these rightful claims go? And there had started to develop this inroad through 43A. So I think it was meaningful in that story. I think Sears-Compco, though, is a very momentous development in trademark law, not because it shut off these claims, which it didn't, but there's just that reorientation through. We have statutory language that we can bring the same claims in, took away the kind of fallback right to copy theory. That language just fell out of how the law developed after that.
Can I add one thing? It was uniformity. They wanted a law that would be uniform, and so the federal law gave them that opportunity. But that also explains why, when the effort to add trade secrecy to 43A didn't work, they fell back on the uniform law process.
Okay, so I certainly have some. I certainly have some additional questions that I could pose, but we have a little less than 10 minutes left. So I'd like to give our audience a chance to ask questions of our distinguished panel. And I see Professor Ramsey in the back has a question for us.
First of all, I want to commend you all. This is an all-star conference. Conference of all-stars. So we see in the context of IP and First Amendment disputes often focus on history. So in Eldred and Golan, right, that you're talking about the traditional contours.
Lisa, I'm just going to bring you the microphone just so that we get your question on the record here.
Come on there.
In the context of IP and First Amendment law, you often see a focus on history. So in Eldred and Golan, right, the traditional contours of copyright law. More recently in Vidal versus Elster, focus on history and tradition, which is not originalism, but something else. And so, would you recommend that attorneys in their briefs or academics in their law review articles focus a lot more now on history to provide guidance to the courts? Because as you know, right, some courts, justices are focusing on the plain meaning of the text, but it seems so critical to take into account history. But of course, there's a big debate about history. And at least, for example, in Elster, there was like selective use of certain kinds of history. And so I know Rebecca Tushnet has talked a little bit about, what exactly are we looking at, et cetera. So I'm curious, should we be focusing more on this both as attorneys and academics?
I certainly think academics should focus more on history. It's not clear to me that practicing attorneys are equipped for it, and that's not a knock on them. They just have different demands on their intellectual capacities with regard to the clients they represent. And also, law office history is, that's not a compliment when you call something law office history. So I think the extent to which academics can provide well theorized and sort of robustly done good historical work. That is something that attorneys should be able to rely on. Courts, more importantly, should be able to rely on sort of dispassionately. I wouldn't want that task to be sort of outsourced largely to the practicing bar, for reasons I think are pretty obvious.
So, Saurabh, could I ask you a question in terms of where that response comes from? Because the entire exercise we're involved in assumes a kind of good faith, comprehensive effort to assess a historical record as a whole and its full implications, which I agree that academic discourse is well suited to. But in the context of judicial decision making, where one person's history is either anointed as the correct version of history or history is cherry-picked, I wonder sometimes about the challenges and wisdom of relying on history to constrain or suggest to judges how cases would be decided, given the way I perceive the Supreme Court uses history.
Okay, so this is a terrific question. I don't disagree with you about the susceptibility of judges, and not only on the Supreme Court, to cherry pick history to favor, even if it's not for nefarious reasons, simply just a view of the doctrine as they think makes coherent sense. I think my apparent, optimism is that I'm not fighting the hypo. Lisa's question, Professor Ramsey's question, is fundamentally that, can we equip judges to do this well? I think the answer is yes, and that academics are the ones to do it. I think your question is the follow-up, which is that if we do it, then will judges make responsible use of this? The answer is maybe. So I think my answer is a necessary but not sufficient condition for judges to make responsible uses of history.
So let me just ask a follow-up here, because so now somehow my former hat as an evidence teacher plops onto my head, which is that history is not litigated in an adversarial way, the way many other propositions in court are, right? You don't have witnesses who testify to history. So if we're going to get really good history being done for purposes of judges deciding cases, do we need better vehicles for getting history in front of judges than the present trial process we're stuck with?
Yes. Yeah, I'm going to make an argument. So one thing you have to understand, the battle about trade secret law in large part today is not in court. It's in the regulatory setting. And so what you have is federal government regulators deciding whether or not information is going to be made public, and companies claiming trade secrecy, and no process for litigating whether it is actually a trade secret. So in that context, history is really important. They need to understand. The law and history is really important. So I think they need to understand. But I will say, my experience as a litigator in California for 17 years, when I tried to educate judges about the history, it was an utter failure in most cases. And I think we have to kind of solve that, because the law is not only not being interpreted correctly, it's not even being found. The correct law is not being found and applied correctly, and it's very frustrating to teach what you think is the correct law, and then read a case and go, how could it be so wrong? So I don't know what the solution is, but it's definitely
The plain text of the statute is the solution.
Okay, so a couple minutes left. Time for one more question, and the person I saw is our own Professor Zarzai.
Thanks so much for these very erudite and indeed quite concise histories. I think the word that I didn't hear was capture, and I wonder whether anybody wants to weigh in on the role of industry and the way that the industry interests have shaped or evolved around the law, depending on your account. So, Mrs. Wiggins.
I can start with a kind of a quick answer. So I have incorrectly given Rogers way too much credit for how trademark law developed, but it was an easy protagonist in a short story. But he was the lawyer for a certain kind of client, and so he, like Frank Schechter, kind of saw trademark law through the eyes of particular kinds of clients. And those clients, when you think about that period, those clients, I mean, that was the shift of the economy in our country, so I think they were very in tune with the needs of this, nationalized, internationalized, large corporation trademark needs, and I think that's reflected in how the law developed.
I can chime in a little bit. Obviously, a huge chunk of the legislative history of the Copyright Act is large economic actors getting together and figuring out what kind of law they would like to work under. And it's entirely fair criticism of the 1976 Act that any number of, little person interests, for lack of a better word, were ignored in the way the 76 Act came out. I think you can make that same criticism of the DMCA, of large actors getting together and figuring out how the world works. I would also like to add, just as one other possibility here, which is we're living in a world, or we may be living in a world, where intellectual property rights are large, or at least intellectual property practice, not use the word rights, intellectual property practice will be defined by global settlements and licensing decided by particular classes of actors. So if artificial intelligence companies and large publishers reach an agreement that these are the payments that are owed in order for artificial intelligence to exist, there isn't any reason to think a priori that all the necessary voices to reach a good solution have been heard. But because those settlements will dominate everything else, it'll be almost impossible for anyone else to get in there as a matter of litigation. And then I think what becomes fait accompli will be as good as codified.
Okay, well, that seems like as good a time as any to wrap it up. It's wonderful to have these four panelists here because they make my job really easy. So I'd like to thank all of them and give them another round of applause.